This is part 2 of constitutional law, looking at the powers of Congress, the 13th Amendment ban on slavery, 14th Amendment and equal protection, and the 15th Amendment and voting rights. Looking at the powers of the president, domestic powers. The president has a power of veto, must use this within 10 days. If the president does not use this within 10 days and Congress is in session, the bill will become law. If Congress is not in session, this is known as a pocket veto. The bill dies on the president's desk. The president has no line item veto power. The president has the power to appoint officials with the advice and consent of the Senate. The president may directly appoint inferior officials, and these are officials that are supervised by Senate-confirmed appointees. The president may remove officials. This is not discussed in the Constitution, but the president may generally remove officials without cause, and Congress cannot limit this to for good cause. One exception is federal judges. They may only be removed by impeachment. Looking at the powers of the president over foreign affairs, the president has exclusive power to negotiate treaties. Treaties must be ratified by 2/3 of the Senate. Treaties are subordinate to the Constitution but are supreme to inconsistent state law, where a treaty and or of an act of Congress conflict. The most recently adopted controls. Then it limits on the executive, the impeachment power. The House may impeach, which means the House brings charges against the president by a majority vote. The Senate then tries the president by a 2/3 vote. Looking at appropriation on the president may only impound funds not already appropriated. Delegation of legislative power. Congress cannot delegate legislative duty. Seems to make sense. The Congress may, however, if it is combined with an intelligible principle to guide delegation. One thing that Congress may not do is it may not delegate impeachment and war power. Immunities and privileges. The judiciary is immune from judicial acts, but not from judicial activities such as firing a court employee. Legislators are generally immune from statements and or conduct in the regular course of the legislative process, however not bribes, obvious. The executive communications are more likely to be privileged in a civil context than in a criminal context. And the executive is immune from any acts that are part of their official duty. They are not immune from acts committed prior to becoming president. Advisors to the president may be immune as well if they are performing special functions for national security and or foreign policy. Looking at the federal system, federal and state powers. Constitution outlaws federal powers. Any powers not granted to the federal government in the Constitution are saved to the states. That's from the 10th Amendment. However, the Commerce Clause generally takes over states' 10th Amendment powers. And remember, the Commerce Clause is Article 1, Section 8, Clause 3. Article 1, because Article 1 is the congressional one. Article 2 is executive, and Article 3 is the judiciary. In addition, where state and federal laws conflict, the federal laws generally win. This is the Supremacy Clause, Article 6, Paragraph 2. State regulation and taxation of commerce and the Dormant Commerce Clause. If Congress has not regulated in an area, states may regulate if that regulation does not discriminate against out-of-state commerce, unduly burden interstate commerce, or regulate extraterritorial activity. Now, even if the regulation is discriminatory, the state regulation, it may be upheld if it's important to a local interest and there are no other means available to achieve the purpose. Now, a state may fully discriminate if it is a market participant and not regulating. This goes to the South Dakota case where they wouldn't sell concrete to an out-of-state contractor, only sell to in-state. So the state can discriminate if it's not regulating, it's a market participant. Looking at the burden on interstate commerce, it's a balancing test. You look at the benefits of the state law versus the burdens on commerce. Federal preemption of state law, there is express and implied preemption. Express preemption is narrowly construed, may have a savings clause. This is in a federal law, a clause in a federal law that saves state laws and or regulations that regulate in the same area. Even they might not directly conflict with the federal regulation. There's implied preemption, however, this is where Congress totally regulates and or occupies an entire field or area of law, or where state law directly conflicts with the federal law or indirectly conflicts with the federal law. Relations among states, full faith and credit, is Article 4, Section 1. States must give full faith and credit to valid judgments of other jurisdictions. This is where the jurisdiction is proper, the adjudication is on the merits, and it is final. Moving on to individual rights. To employ constitutional protections, a state action is a necessary prerequisite, and the state action must be intentional and not negligent. No intentional state action, the courts have no role in adjudicating it. Procedural due process is the 5th and 14th Amendment. It's fundamental fairness. It's a right to notice and to be heard. It's a neutral third party. It's protect liberty, physical freedom, fundamental rights, and freedom of choice and or action. It applies to property, which may include public education, continued welfare benefits, and or disability benefits. Looking at procedural due process and the amount of process due, consider the interest affected, the risk of deprivation of that interest using the current procedures, and the value of any additional and or substantive safeguards, as well as the burden in providing those safeguards. The more important the interest, the greater likelihood additional safeguards procedures will be required. And that completes part 2 of constitutional law.